Okay, could the next witnesses please take your positions at the witness table? Sure. A lot of confusion. Okay. For the record, could you please state your names and your positions in your organizations? I think starting from Ms. Lau.
Yeah. Good afternoon. My name is Lau Jun Ni. I'm the Vice President of the Singapore Press Club.
Good afternoon. Zakir Hussain, Committee Member of the Singapore Press Club.
Patrick Daniel, I'm President of the Singapore Press Club.
I'm Wong Tao Jun, President of the Singapore Corporate Counsel Association.
I'm Angeline Lee, President Emeritus and immediate past President of Singapore Corporate Counsel Association and also legal counsel at SPH and advisor for the Press Club.
Stanley Lai, Mr. Chairman. I'm from the firm of Allen and Gladhill. I'm a partner there, and we were responsible for the preparation of the report that is before the committee.
Thank you. Good afternoon. The evidence that you'll be giving today before the committee will be taken on oath. If you so desire, you can take an affirmation. The clerk will now administer the oath.
Our witnesses, please rise. I will administer the oath first, and subsequently, after the oath is taken, I will administer the affirmation. Will witnesses who are taking the oath, please hold the Bible in your left hand and raise your right hand. Please recite the oath together.
I, Stanley Lai,
Swear that the evidence which I shall give before this committee shall be the truth, the whole truth, and nothing but the truth. So help me God.
Witnesses taking the affirmation, please raise your right hand and recite the oath together.
I,
Lau Zakir Hussain, do solemnly, sincerely, and truly declare and affirm that the evidence which I shall give before this committee shall be the truth, the whole truth, and nothing but the truth.
Thank you. Please be seated. Welcome to the public hearing on the Select Committee on Deliberate Online Falsehoods. The focus for today's evidence gathering session is for us to pose questions to you, and you have all taken a solemn obligation to answer our questions truthfully. And I will now call upon Dr. Daniel to lead the questions.
Thank you, Mr. Chairman. Good afternoon, ladies and gentlemen, and thank you for your submission and for coming before us. What I propose to do is set out a few general statements, see whether we agree with those general framing of the situation and the issue at hand, and then we can perhaps go through the submission. I note that the submission is in distinct parts for the Press Club as well as for the Corporate Counsel Association. I would assume we will take them in the parts that they have been submitted separately, and then perhaps we'll invite commentary from you relevant to the parts of your submission that you're interested in. And then after that, we'll come back to some general principles and ideas, and I'll open up the floor to my colleagues. I would take it that all of you agree that deliberate online falsehoods are a serious problem that faces our country and our society. I would need for you all to...
You'll have to say yes or no for the
Mr.
record.
Chairman, can I assume that it's yes unless there is dissent?
We agree.
Silence being consent. Okay. And this the extent of this serious problem is a potential threat to our social cohesion, to our peace and stability, and potentially to our national security as well. Would you all agree with that statement? Yes? Okay.
Yes.
As a result, the status quo, if nothing else, can we at least agree that the status quo is unacceptable?
Yes.
Okay. So if we can go through your submission, if I can start at the page 3, paragraph 2.3 and 2.4, quote, the sentiments are that the treatment of innocuous dissemination of falsehood should be distinct from the treatment of the spread of online falsehoods with specific intent to harm or destabilize our society. So if I could synthesize that together with the diagram from Dr. Claire Wardle's work and the other information in the 2 paragraphs, you accept that there is a spectrum of falsehood, some of which must be stopped or prevented. The process under which we do that must deal fairly with genuine errors and allow some space for fairly innocuous satire and parody as part of the normal process of media and creative work. You would all agree with that, right?
Yes.
So if I go on then to your paragraphs 2.51, 2.52, you, in your submission, talk about intermediaries. Now, you have labeled both internet service providers and digital platform owners and operators as intermediaries. Now, I'm going to just ask you a little bit of explanation around that. I presume by the internet service providers, you are talking about things like our telecommunications operators, Singtel, StarHub, for example. And digital platform owners and operators, you are referring to, for example, Facebook, Google, Twitter, as distinct from media companies.
Yes.
Then you go on to refer to gateways and channels. What do you mean by gateways and channels as distinct from your intermediaries? In 2.52. Or are you just using an alternative way of referring to the same group of companies?
We tended to mean the same thing, because these are the gateways and channels through which the information or disinformation is disseminated.
Okay, so we're talking about your intermediaries, your gateways
Yes.
and channels as one group.
That's correct.
All right. So I'm a little bit confused looking through the submission. I just want to get some clarity. On the one hand, in 2.51, you talk about targeting the source of creation and publication and how this might be difficult because some of those actors may be from overseas. But later on, you talk about curbing the spread of deliberate online falsehoods through targeting gateways and channels. Now, if they're the same group, I mean, people like Google and Facebook are potentially overseas. Singtel and StarHub may be here. But you're treating them as one group of entities. And you're saying that we should treat them separately depending on whether they're overseas or whether they're local. I'm sure that's not what you mean.
Perhaps I can, Dr. Bucheri, I can perhaps cast some light on the question that you're asking. I think the first point to make is that you correctly identify and ask the question whether there are 2 groups as opposed to one particular group. We will just say that in relation to a presentation that we actually conducted for members of both organizations here before you, we did receive feedback following that, covering a range of different subjects. And that is why I think that there is a certain, at times, a difference in the way certain groups of people are classified. And I think that will best explain the reason why they appear in such light. This is actually very much a document that has resulted from a big collocation of different views from
Indeed.
different stakeholders.
But I'm trying to now establish what your position is on the matter.
Can I address that last question? Actually, para 2.3 talks about the source in terms of the originator of the falsehood.
I understand.
Whereas 2.4 talks about the channel through which that falsehood is purveyed. So 2.3 says, where possible, of course, it's ideal to get to the source of the falsehood. But 2.4 says that while that might be ideal, you should also tackle the channel through which it is purveyed.
I understand it is actually, I'm asking with respect to your latter point,
Yes.
do you draw a distinction between a telecommunications company and a technology company such as Facebook and Google? And do you have a different position of expectation for one or the other?
Okay. Speaking for the press club, for sure. I would let my colleagues from the SCCA think. It is actually our position that it must be differentiated.
Can you explain why?
Certainly. This is actually a key point from the press club's point of view. The reason why you need to differentiate the two groups is that actually the social platforms have actually increasingly become purveyors of news, content, and information, whereas clearly the tech people are not in that space. And so because they are the...
Sorry, when you say the tech people, you are referring...
I'm talking about the ISPs, the
Okay. Telecommunications providers.
telecommunication people. Although we have grouped it as intermediaries, but the way we see it is that they're two actually distinct groups. And if I can just explain that point about how they've become media platforms. Firstly, they are actually big purveyors of news and information. And secondly, they derive the majority of their revenues from advertising. So in many ways, they are media companies. So while Facebook and Google may not want to sort of describe themselves as publishers, but actually they are publishers, although while they may not be the source of the news, but they are publishers. They put out content and they derive revenue from that content. So for that reason, they are actually very different.
So your position would be that the technology platforms, the social media technology platforms, should be regulated in a manner that is closer towards a media company than it is currently.
That is indeed the position of the Singapore Press Club.
And what is your view on the telecommunications providers?
Actually, telecommunication providers, I have don't have a strong view on. I think that so long as, they can only control information from a particular source and where it gets to. They can't control the actual content.
Indeed.
You can't differentiate. So while you may want to include them, you have to sort of restrict it to just saying, for example, information coming from a particular location should be blocked.
Which is the current technological capability that they have.
That's all. So for that reason, the regulations necessarily have to be different.
So you take a different position on these. For the SCCA, would you have a similar position, or would you like to comment?
We don't have a position on this, but we would be happy to support the views of the Singapore Press Club in this manner.
Thank you.
Can I just add that one feature of the social media platforms in purveying information is that they don't distinguish between falsehoods and non-falsehoods. Everything just goes through under the current regulatory regime. So it's actually the fact, and it's not surprising, that they are indeed the major purveyors of those falsehoods. I mean, I'm not saying anything controversial because the fact is it comes through all your social media platforms. And because of they've increasingly become purveyors of news and information, less so than just being a social platform. They're now actually purveying news and information.
So I would presume that that is your point in 2.53, subsection 1 and 2. You believe that in these paragraphs, when you refer to intermediaries, you are suggesting that intermediaries such as Facebook, Google, Twitter, should have some view on what is true and what is not? Because they would take the position that they're not in a position to be an arbiter of truth, that it is the people who create the material who should be the arbiter of what is true or not true, or other people should fact check and so forth, that they as a platform are not in a position to do so.
Yeah. Again, speaking for the press club, yes, indeed, they've been taking that position, and that's not a position that we support.
If they make the argument that they are unable to be the verifiers of truth, and let's say for the moment that we accept that that is the position, then would I be right in assuming that your position would be that they are then required to comply with directions from people who are arbiters of truth?
Yes, of course.
Okay, if I could move on, any other comments up to 2.5, para 3? Any other? If not, I can move on to section 2.6.
Sorry, can I just
Yes?
make an additional small point?
Please.
Because they derive a large part of their revenues from advertising, the content of advertising should also be covered in this discussion, because you can have false advertising as well, paid for. And so you do need a different, well, a platform will have different policies on whether it's paid for or not paid for. You could have a situation where they control unpaid for falsehoods or questionable, problematic content, but they might be more lenient if it's paid for. So both paid for content, it could be sponsored content, or it could be plain advertising, should also be covered in whatever regulation that is being considered.
Could I summarize that as there should be no variation in the expectation of truth, paid or unpaid?
Yes.
Unless you're paying for fiction, I presume.
You got anything more to say?
Yes, sir, please.
Sorry, Dr. General. Perhaps I can just clarify the statement I made previously when you had asked whether the Singapore Corporate Counsel Association has a position on what you had on that question. And I said that the Singapore Corporate Counsel Association does not have a position on that, but we can appreciate the analysis of separating the two types of intermediaries.
Thank you. Okay, if I can go on to para 2.61. These are the concerns of the members of the SCCA. And again, if I may summarize, essentially you are concerned that corporate entities themselves can become targets of deliberate online falsehoods, and that these can have very significant real-world effects. And we've just had NTUC give us some discussion about that. And would it be right to say then that SCCA's position is that the status quo with respect to the risk of corporate entities being targets of deliberate online falsehoods is not appropriate, and we need to take some steps in that direction to fix that?
Yes, that is correct. And perhaps with the permission, though, of the committee, perhaps I could share a story with the committee. I have a very dear auntie of mine, and who, bless her very kind heart, she has, however, a very deep resentment of cockroaches. And one fine day, she found that there was a cockroach in her bathroom. Now, she's only a little bit above kind of 5 feet, which means that, and this happens to be a flying cockroach, which means she can't do very much about it. Her options to destroy the cockroach, it's very limited. So in a stroke of brilliance, she decided that she would take a can of insecticide, lock herself up in the bathroom together with the cockroach, and attempt to exterminate the cockroach. Of course, at the end of the day, she managed to, but she also ended up choking very much on, the insecticide that she was spraying in the closed bathroom. I wanted to share this story because I think we all agree that deliberate online falsehood is probably the cockroach of our times, all right, and probably have perhaps a far more deeper impact, all right, on society and on business. I think in fact, from the position of the Singapore Corporate Counsel Association, that we feel that there's impact on business, and if there is any legislation or regulation to deal with those, that they should also extend those remedies to corporates who are victims of of deliberate online falsehoods. But of course, our concern is that we don't end up like my dear auntie.
Indeed. We will get there in a minute, Mr. Wong. I want to firstly ask you to backtrack a little bit.
Sure.
Well, do you feel the insecticide we have today is sufficient? Or should we be providing additional, give her a slipper that she can throw at the flying cockroach? So my question to you is, today, do you feel that with respect to corporate entities, there is sufficient protection against deliberate online falsehoods?
Okay. Our position is no.
Okay. Can you explain why, under in today's circumstances, the recourse available to corporate entities through the courts is not sufficient in your view?
Okay. A couple of ways to look at it. One, of course, is the speed with which the court system could react in such a circumstance. All right. As we know, deliberate online falsehoods will and can spread very, very quickly, and more importantly, there is very little. There's not a lot we can do to determine where that source is. All right. So I think currently what we know is that recourse through that system, the court system, the judicial system, it's limited and it's slow and potentially very costly.
So if there were further steps to address deliberate online falsehoods, you feel that in general it needs to be faster? It needs to be more effective with respect to the falsehood being taken away?
That's correct.
And hopefully cheaper?
That is certainly correct.
Yeah. Okay. And by corollary, I mean, you can see where I'm going with this, that would be similar to what we need to do on a national level, that our current levers and interventions perhaps are too slow, too burdensome, and too costly for some types of deliberate online falsehoods.
That is correct.
Dr. Janil, can I add?
Please, ma'am.
Actually, I think from our perspective, it is not a question of whether we have not sufficient legislation, but it is the interpretation of what DOFs are. I think, with some form of clarity on the definition, we can at least, understand where the gaps are. And from the perspective of risk management, to put in controls, we need to have a common understanding. So if there are different interpretation of what DOFs are, then certainly it calls for a lot of discourse.
Well, Ms. Lee, do you agree broadly with the statements made by several other representatives and people who've come to give oral submissions to the committee that in looking at deliberate online falsehoods and how we define them, one needs to look at the intent behind that there is a deliberate attempt to spread mischief, malfeasance, that it is online in the sense that we have to treat all platforms as being relatively agnostic, that it needs to be demonstrably false, a falsehood around fact as opposed to merely opinion and commentary. And actually there's a fourth dimension, that it needs to have some degree of significance affecting national security, race, religion, our economic circumstances, our political circumstances, or potentially our sovereignty, that there must be some significant impact. Do you broadly agree with those sort of four categorizations of the types of deliberate online falsehoods that we are dealing with?
Indeed, I do.
And so if we use that as a framework going forward, you would support further interventions to make sure that such falsehoods are stopped and prevented?
It would be correct, but I would expect that there would be a nuanced, measured proposition for it.
What do you mean by that?
Well, in the same way, we do not want to have his aunt, smothered by the thing.
But no, let's move away from analogy.
Okay.
Let's deal with the facts that, if we're talking about a deliberate, malicious, online attempt to manipulate information or perception around national security, race, religion, our social harmony, our sovereignty, our social cohesion, what nuance would you like to further develop around that?
Under those circumstances, I don't think we need that form of clarity.
Thank you very much. If I could move you to...
Sorry,
Yes,
Dr.
sir,
Jones,
please.
may
Mr.
I
Daniel?
just come back to the question of definitions? What you described is, of course, difficult for us to disagree with because it's clear that it's malicious, etc. But there will be a lot of gray areas, as to what exactly, falls under that definition. So there may be instances where it's arguable whether A, it's malicious, B, it's false, so we do need some way in which that can be
I understand.
ascertained.
Mr. Daniel, if I could
ascertained.
extend your argument today,
Yeah.
if I remove the word online and said there are people in our society who are deliberately spreading falsehoods maliciously to affect our national security, our race, religion, our social cohesion, etc., etc., etc. Are you confident we have means to deal with them, to establish whether or not these are indeed false and deliberate and malicious and significant?
Through the court system, I would say yes, through defamation, there may be specific pieces of legislation that you could use, but is it comprehensive? I'm not so sure.
So you're worried that we are not catching some of the falsehoods, or that we are not...
It may not rise to, for example, the level of outright defamation.
No.
But falsehoods can be spread.
I understand. That actually
And
wasn't...
I'm quite sure you're not catching all falsehoods anyway. So
Indeed.
and to that extent, maybe.
Sorry, I may have misrepresented myself. It was the issue that you're suggesting that it is arguable whether we would be able to adequately define deliberate online falsehoods of the nature that I have described. So I'm putting it to you that today we could, I would argue, reasonably be able to define deliberate falsehoods that fall into those categories that are not online. We may argue about them, we may have a difference of opinion about them, but we have the ability to address the issue of identifying and defining those falsehoods.
Two parts to that. One is deliberate, the other is falsehood. I can imagine situations where you will have difficulty proving that it was deliberate and intentional.
No, indeed.
Yeah?
I'm not...
I can also cite you instances where whether or not that falsehood is provable is a challenge.
Indeed, but that the point I'm making is, but we do have the ability to engage in this
Of course,
space
yes, of course.
with some back and forth, with some room to argue, with opportunities for redress and appeal.
Yes. The only point I'm trying to make is, or I think we are all trying to make, is that those words that you use, deliberate falsehoods, etc., need clearer definitions. And
Okay.
I would submit that in current legislation and in current codes of practice, it is not so clear. It is not so clear both ways. If I can give you an example of what I mean. In the Broadcasting Act, for example, there is a code of practice which actually makes it very clear that putting out false news is a breach of the code, right? But what exactly is false is not defined. So we have a situation now where radio companies have been fined under that provision for putting out news, yesterday's tape of news that get fed into it. So we're producing, the mistake was that instead of putting out today's news, erroneously yesterday's news was put out,
Yes.
and that was deemed false under the clause, when in fact you could argue that dated news, I mean, you can't have a situation where it's true yesterday but false today.
I understand.
Do you know? So, and then again, the definition of deliberate, or it's clear that that provision was meant for intentional falsehoods.
No, I understand, Mr.
But
Daniel.
because it's not specified, they say, well, it doesn't say it must be deliberate. So you get fined for that kind of situation. So again,
So
it's a
further
question
clarity in the law would be useful.
yes, further clarity in defining the various terms, falsehoods, which, is it deliberate, is it unintentional, etc., is necessary.
Thank you very much. So, no, we're okay. If I could take you to paragraph 2.81, I just want to be clear that in your second sentence, you're talking about curtailing serious-minded journalism and news reporting in Singapore. But can I put it to you that with respect to serious-minded journalism and news reporting, there is no room for a deliberate online falsehood, assuming, from your last point, that we are able to adequately define that with some degree of clarity?
Thank you for that caveat.
Okay.
With that caveat, yes, we agree.
Okay. I draw your attention to para 2.84 and the statement, there is a real and legitimate concern about the practical difficulties in fully verifying information that is expressly attributed to sources, whether named or unnamed, including verification with and or against government data. The reason I bring this up, and I'm happy to take comments from any of the panel members, isn't this, in a way, going against the grain of what is expected of all journalists?
Yeah.
We had a representation from some of your professional colleagues from CNA and MediaCorp and SPH. I think the phrase that they used was accurate, contextual, and timely, with accurate coming first. And the other phrase I seem to remember, we can check the transcripts, was a zero tolerance for inaccuracy, and that any error was to be treated with some degree of angst and soul searching. So I'm worried that what you're trying to argue about here is that there are some situations under which we should accept a lower bar of truth from journalists, but perhaps that is not what you're saying.
I do need to apologize for not making this particular thing clear. I can cite you one big area where this applies, and that's got to do with foreign news, regional news, where we contract with news agencies to carry news from Reuters, from Bloomberg, etc. And we have to take it on trust that they've done a professional job. There is no way that we can run stories where we have to verify every fact in those stories. But they are professional news sources, and we sometimes query their factual information and check, and we call them and say, hey, this is potentially defamatory, or and are you sure, etc. But that's very rare. Most times, when news comes through the wires, we take them as accurate.
Because you have the same professional expectations of quality on
On
those
their part,
journalists that you
yes.
have on yourselves.
Yes. So what my colleagues might have said about zero tolerance actually pertain more to domestic sourced stories.
But in principle, you agree with their position?
Yes,
that,
of course.
That as a professional journalist,
Yeah.
you would have zero tolerance for inaccuracy.
Okay, I would also say, secondly, that this is a summary of views. This might have been expressed by members who were at the forum, that sometimes you rely on a particular source and you go with them. That is at times called for. You do an investigative piece, you get a piece of information, you don't go with one source, you double check that with a second source, you go with a third source, you try and get source material to satisfy yourself, but ultimately someone has to make a judgment on the veracity of that story. And there are times when we do go, after taking, all the soundings that we have, clearing it with lawyers, etc., and we go with the story. But we've taken professional care before we do that.
No, I understand the difficulties in ascertaining absolute truth and veracity on every single occasion. But in the example that you're citing, the risk of then not being completely true is a professional risk that you take and a matter for your professional judgment. Would I be right to characterize that?
That is true.
Rather than, as I worry, this paragraph has suggested,
Lower standard?
yes, that
No.
it is an expectation that in some circumstances we, the public, should have a lower expectation of standards from journalists. In other words, if you make the professional judgment,
And
you
get it
make the
wrong.
call, and then you get it wrong, you call it a mistake. And you take steps to address it as a mistake.
Yes, of course.
I mean, would that be an appropriate characterization?
Sure.
I don't know if other members want to.
Yeah. Yes, I would agree.
Yes, that would be the case.
So I better check with my colleagues whether they agree with me, otherwise.
Yes. So we
Yeah.
just have to get the characterization
Sure,
of your
sure.
paragraph 2.84 correct, right?
Okay.
Please.
So if I may just clarify, there could be situations as well where perhaps stories could be set up, okay, and journalists genuinely misled.
And-
So if you're doing an investigative piece or an enterprise reporting piece, despite the attempts to verify and corroborate the information, we do not go with just one source. We would definitely look for two or more sources in situations like that where there is no forthcoming official response from the organization. You may have to go through various channels to get at the real situation. So in this case, sometimes there may be occasions where it could be a setup for a certain purpose, and a journalist could be genuinely misled despite all the best efforts to verify that information.
We do and have been sold pigs in the poke sometimes.
And then you call it as such. Okay, if we could move on perhaps to your para 2.8.5. Here you quote the marketplace of ideas in your first phrase, and then later on in the last sentence, the marketplace has also galvanized counteractive measures to combat the spread of deliberate online falsehoods. So I put it to you a few comments, and I would appreciate whether you agree with me. The first is that in those areas where the marketplace of ideas is assumed to be working well and has galvanized lots of measures, whether counteractive or not, in an attempt to combat the spread of deliberate online falsehoods, these measures have not been sufficiently or if at all effective. But yes, it may well have galvanized quite a lot of effort. It may have galvanized quite a lot of concern, but that alone has not been effective at stopping the production, spread, virality, and effect of deliberate online falsehoods.
I would first distinguish between factual information and opinion. Where it comes to factual information, I agree with you. It's a deluge that you're dealing with.
Well,
But
let's limit
this-
ourselves to factual,
right.
because that is what we're concerned about.
Sure, no. But this particular paragraph deals with how you want to deal with opinion.
I understand.
And I think the danger is that if we don't make that distinction, it will tilt towards accusations that we are not allowing free
I understand.
expression of opinion. That's our only concern.
But does that
Can-
not...
Can I say something?
Yes.
Mr. Daniel,
Yes.
I think we should be clear about something. We are focused on deliberate falsehoods. I accept your point about opinion. I think, as you would know, and I complimented you on your law of defamation. Opinion of any category, however irresponsible, is allowed as fair comment as long as it's based on a substratum of facts. And you have identified the substratum of facts. Likewise, opinion should generally not be the target of the law unless that opinion itself is malicious based on facts which you know are false. So the focus of our discussion ought to be facts and facts which are deliberately false. I think that has got to be the rubric. I accept your point that we should not get into opinion. I think we are on common ground.
Yes, we are.
Thank you.
Okay. I think, let me just. If I could take it to your para 3.2, you are essentially agreeing that there are limitations in existing laws and that whatever steps should build upon and work in concert with the existing laws, obligations, essentially level the playing field and have some coherence with our current standards, our current conduct for all the players involved.
Can I just say something, Dr. General?
Please.
I don't mean to interrupt. That is what we're saying in paragraph 3.2. And in this context, I think I should also say that because the submission was prepared based on a collation of different views from the members of the two organizations stated therein, you may not appreciate, or you may have noticed that we don't really go into the remedies involved in the respective instance, because I think remedies will be perceived differently by different stakeholders within this group. But can I just say that in the context of my understanding of the proceedings that have transpired so far, I can understand why an executive takedown regime may be one of the options that this committee will be considering. From my own experience in the copyright field, I have witnessed limitations to takedown actions that we have applied so far. Notice and takedown regimes may not totally remove the scourge of infringing sites. Then you also have judicial site blocking, which is a recent measure. And even though it is a no-fault system, I have seen tireless negotiations over the issue of costs between content owners and network service providers, subjecting themselves to a remedy in court. One would ask whether a takedown regime would work effectively in the context of file sharing, for example, or in torrents, or peer-to-peer. And I do liken, in many ways, the dissemination of DOFs to that kind of decentralized, proliferated regime. And whilst I do understand that executive takedowns would be perceived to be an effective regime, I just want to offer my modest views to the committee that it should not in of itself be a substitute for the vigorous prosecution of the provenance or source of DOFs. I recognize that locating the culprit in jurisdiction may not always be practical. But I think the strongest effective measure to remove DOFs is also to make sure that there is an equally prescriptive and prohibitive consequence for the articulator in the first place. And then I think with that, the combination may yield the outcome that I think we would seek. And this is from experience where if content owners just look at the takedown notices in relation to network service providers as being the short-term solution, it doesn't remove the scourge of, where is the actual culprit
I understand.
that actually is the provenance. So if you deal with the provenance strongly, you set also a message for everything else to follow in relation to DOF. I just make that comment. It's not really spoken to in the submission, but I think that is a view I would offer committee.
But you agree that the type of executive takedown action that you're describing may have a role to play, but it is not exclusive to other types of action as well.
Oh, absolutely. I mean, I'm not saying that, I think there is I think in addition to that, it's the strongest edict against the actual source, because that is where the trouble originates from, regardless of where you're from. I think having those rules in place would be critical and would actually encourage behavior throughout all the different stakeholders and different layers of content providers.
Thank you very much. If I could just, for paragraph 4.9, it's actually very similar. This is in your summary, very similar to the issue that we raised in your paragraph 2.84, which is about the quality expectation of accuracy for journalists. 4.9 is essentially a repetition of the key points in 2.84. I presume that you would similarly stand by a similar understanding of the fact that we would have high expectations of no inaccuracy from the professional journalist around facts.
Yes, that's right, except that this paragraph goes slightly beyond. Maybe we didn't make it so clear, but there should be a range of remedies, everything from corrections and apologies, right of reply, takedowns, and of course penalties if it is ascertained that it's deliberate, intentional falsehoods.
Indeed.
Yeah.
And
So that's what we were leading up to saying. But you're right that we expect the same standards.
so your proposed set of solutions would include some degree of media literacy, some degree of issues with respect to, for example, fact-checking,
Yes.
and then a range of potential regulatory and legislative measures,
Yes.
all of which need to work in concert, none of which individually is sufficient,
Yes.
but taken together may be far more effective.
Yes.
Thank you very much, Mr. Chairman.
So if I may add, regarding the executive takedowns, could I also suggest that in regards to takedown orders, that the respondent be allowed to apply for it to be set aside in all fairness, be given that chance to apply for the setting aside of such an order if it comes to that. And further to that, there should be also perhaps substantive grounds in which the respondent can be allowed to set aside that order.
So this was in your...
It's not in the paper per se, but I think if we draw from other existing legislation, there
Yes.
are provisions for this.
Well, your para 4.5 does speak to a mechanism for essentially disagreements and dispute resolutions around decisions that are made. So I think the point is well taken.
Mr. Shamgar?
If I may pick up on the last point, and some of the earlier points, I think really in terms of remedies, based on what Dr. Lai said and what you said, Johnny, is that maybe some sort of a quick, say, executive action to take down, coupled with a remedy to, if the other party wants to challenge it, subsequently to go and take it down, or rather to reinstate it back. But really the quick takedown is essential to deal with the virality and the nature of the digital age, coupled with a range of penalties depending on the, if we can use the term culpability, state of mind of the individual concerned. And that may also then deal with another point that I think Mr. Daniel made, which is that it may have been false, but the person may not have known. And that may then, how you deal with it may be related to what sort of penalties are imposed. I mean, in some cases, if there is no intention, but it is false, it could just be a takedown. In some cases, if there is intention and actual deliberateness involved on the part of the person putting it up, then maybe the range of penalties can be higher. So as long as we are focused on falsehoods or opinions based on falsehoods which are, apparent to everybody, as in, when I say apparent to everybody, what I mean is the opinions are made and everybody is aware what those facts are based on which the opinions are made, and those facts themselves are false, then what you do is you have a range of remedies depending on the degree of culpability of the person involved. Would I have summarized the viewpoints of the 3 or 4 of you who expressed it on this point?
Yes, you would have, except that I would add that there must be some way in which the party being penalized is given a proper right to.
I think that's the point
defend.
Juni made.
Yes.
So if...
I mean, you may say I'm culpable, but I honestly
No, I
believe I'm
think,
not, and I try to.
I understand.
So there must be some.
So that's why I think it has got to be probably a multi-stage process, maybe where the takedown comes immediately for the first order, and then the person who feels that he is not culpable, or anyway his post ought to be up, may then be entitled to a right of going to some neutral place to have that decided.
I think Juni's point was just appealing the takedown.
Yes.
I'm going one step further, assuming it's been taken down, and whichever authority feels that penalties should be imposed,
Yes.
because it was.
I think it
culpable.
follows.
Then it must follow that there
just
must be
that
a due process for that.
Just as he has a right to have
Appeal.
the takedown reviewed, if there is any penalty, he must also have a right to have that challenge it appropriately. I think that's I mean, we haven't, sort of buttoned it down to that kind of detail, but that's perfectly sensible and civilized, I think. Yeah.
Thank you.
Thank you.
Minister, can I just add the point that perhaps parallels can also be drawn with innocent publication in the Defamation Act, and how a regime where, if you have, with all the best will in the world, a person acts with innocence in publishing or republishing a falsehood, then an offer of amends can be made. And something like that is I think falls in line with what Minister is talking about in relation to the different categories or the typology of different type of mental state of mind in propagating a DOF. And malice, for example, is another aspect where you either intend to perpetuate the DOF, or you are reckless as to the truth or the falsity of the statement that you're making. And that's another form of mental element that I surmise can be extracted to deal with this.
Yes. We will bear that in mind. Thank you very much.
As there are no more further questions, ladies and gentlemen, thank you very much for your time and for your participation in this select committee process. We'll be sending you a transcript of today's events, and if there are any corrections to be made, please correct them and send the transcripts back to us. Thank you very much.
Chairman and members, thank you for the opportunity.
Thank you. Okay, Sergeant Arms.